Our next speaker will be Michael Hunter, and after him, Ron Michael. Good afternoon.
Good afternoon, Chairman Lieben, members of the board. Appreciate the opportunity to be here. My name's Michael Hunter. I'm a union attorney based in Columbus, Ohio. I primarily want to address the board to encourage you to adopt the preliminary view that questions concerning the eligibility or inclusion of individuals into a bargaining unit that constitute less than 20% of the potential unit should be deferred until after the election, and that persons in that disputed area should be permitted to vote under challenge. There appear to be two broad categories of resistance to this proposal. The first is that the employees, not knowing the final composition of the unit upon which they're voting, would somehow be deprived of a meaningful right to vote. And secondly, that employers will be deprived of a pre-petition or pre-election determination as to the supervisory status of alleged supervisors who occupy the disputed positions. Going to the first objection, concern regarding the composition and scope of the unit, it should be noted that the board has proposed that in situations where there are individuals who are going to vote under challenge, that the final notice of election would set forth notice to the employees of that situation and would let the employees know how that may ultimately be determined. In that case, there really is no difference in that procedure than what currently takes place, for example, in a sonotone election, where the professionals have the right to vote on inclusion or non-inclusion in the wider unit, and there's some uncertainty for an employee in either unit as to what's the ultimate composition of this unit going to be. Or the same occurs when two unions may petition for equally appropriate units, maybe one plant versus three or what have you, and there's a self-determination election. As long as the notice of election informs the employees of what they're voting on and what the potential outcomes could be, and in particularly with the proposed rule, what the methodology may be to resolve those potential disputes, there simply is no infringement upon the meaningful right to vote. The second broad objection to the proposed procedure is that the employer, and the union for that matter, could be deprived of a pre-election determination as to the supervisory status of individuals who one party or the other believes should be in the unit. The proposal to allow such individuals to vote under challenge is simply an extension of procedures that already exist. When the hearing record is inconclusive as to the supervisory status or the managerial status of particular individuals, those individuals have been permitted to vote under challenge. And the courts have approved this process as a well-established method by which the board assures the speedy running of representation elections. Under Harborside Healthcare, unions as well as employers take their chances when there's supervisory issues in dispute, and unions take their chances as well as employers if there's pro-union or anti-union coercion on the part of a supervisor. However, it's not a case of whether or not that individual is predetermined to be a supervisor or not that matters. It's the supervisor's behavior in the election campaign that matters. And whether they're determined to be a supervisor or not prior to the election, it's their status and behavior that determines whether or not they can taint an election and not whether they were permitted to vote under challenge. Thank you.
Thank you.
Any questions?
Just one quick question, and that is it conceivable that the scope or the composition of the union, of the unit might not be an issue which a voter would want to know before he or she casts their ballot?
Might not want to know?
Yes. In other words, the scope or the composition of the bargaining unit, is it conceivable that that would have an influence on how an individual employee might vote?
I'm not sure it would, but the courts of appeal certainly seem to think it's possible that it would have, that if they don't know what the potentialities are, that it might have an outcome. I think as a practical matter, people vote whether they want to be represented by a union or they don't. But I do think it's clear that if the notice of election tells people what the potentialities are, such as you have in a sonotone election, that there's no problem with it.
But would that notice cure some of the problems, in your view, that the courts of appeal have suggested with respect to the voters knowing the scope and the composition of the unit?
Member Hayes, I believe it would. If you look at Morgan Manor, for example, when the Fourth Circuit, in their unpublished decision, denied enforcement in that case, they did indicate that that decision may have been different if the employees in that situation knew there was a knew that the LPNs in that case were in play. And it's because they didn't know they were in play that that became a problem. And here, when the notice lets people know what's in play, I just don't think there's a problem.
Other questions? No.
Thank you. Thanks very
Thank
much.
you for being with us today.